It's been moved. Is there a second?
I'll second.
Was that Commissioner Green, Member Green? Thank you. So Capri and Green, all in favor signify by saying aye. Aye.
Aye.
Aye.
Any opposed? Hearing none. Agenda is approved. Next item of business is review and approval of the minutes from the last meeting, Wednesday, July 9th. Does anyone need any more time to look at the minutes? Does anyone have any changes proposed to the minutes? Is there a motion to approve?
I move that we approve the minutes as presented.
Is there a second?
I'll second.
And we had Cuniff and King. All in favor signify by saying aye.
Aye.
Aye. Any opposed? None opposed. We have an approved minutes. Item 4. Election update and status report by Mr. Rocha.
Thank you, Chair Marks. Let me just set this up real quick. And let me make sure. Sure. Okay. I'm not sure why it's setting up as a presenter. But that's fine.
Okay.
And I will screen share for okay, there we go. So we are at points in the election where it is essentially filing time for candidates. So as you can see on the screen, we are starting fairly close to the filing day for candidates. Clerk Watson and I have already taken the petitions and declaration of candidacy on behalf of publicly financed candidates. They were declared to be a candidate, but we will also go back down on the 26th to the county clerk's office, as well as every privately financed candidate, take in their petitions, and they will turn in their declaration of candidacy. And then sometimes it's the same day, might be a day or two after. The county clerk will then certify them to be certified as a candidate, and that will place them on the upcoming election ballot. Going forward, there is a process for write-in candidates. So right now we had one write-in candidate register with us, and so they are going through that process of preparing for their filing day, which is September 2nd. And then going forward here on the calendar, you're just seeing the process for the county clerk to start sending out ballots. And then the early voting will start on October 18th. Expanded early vote, that's where you usually see about 60 early voting locations. And then election day is November 4th. We do have a potential runoff, and so we've set a date in our election resolution, and we've also talked to the county clerk with this, and so we've set a date of December 9th. If there was a runoff, we'd have early voting starting for that on Saturday following Thanksgiving. So it is a quite short timeline. Just a quick breakdown of some of the numbers. So right now we have 23 candidates that are going to be turning in the petitions. We have one write-in candidate that I mentioned, and we have currently 6 measured finance committees registered with us. Just some interesting numbers that I was looking at the other day, thought you might appreciate, which is the total number of petitions signatures that we received this year were 49,322. That is combined of us verifying handwritten petition signatures and also online, although a majority were handwritten. And then total number of QCs for publicly financed candidates out of about 12,000 QCs that we reviewed, and that does include accepted and rejected. So this is just a total number. And finally, contributions. We had a filing for candidates this last Monday was their deadline. And as of today, candidates and measured finance committees have almost raised $2 million. Well, candidates, 1,900,000, and then measured finance committees. So it is with 7 candidates for mayor, I can say that amount is probably expected. But that is my quick and dirty election update. Do you have any questions?
I've got a couple of questions.
Yes.
Okay. What are the dates for the campaign finance reports going between now and the election?
So up until October, so we'll have one more in September. The reporting period ends on the first Monday of the month. The report is due the second Monday. So they have about 7 days to file that report. And then coming in October, it does pick up. It's every week. And so the reporting period ends on the Friday. The report is due on the following Monday. So it does pick up quite quick.
Okay. And then the measure finance committees, are there any measures on the ballot, or are these just independent committees supporting candidates?
Yes, they're independent expenditures. Yeah,
Okay.
we don't have any measures on the ballot for this upcoming election.
Okay,
Just jump in.
Well,
there.
that could,
Chair Marks, we do have the city does have bond questions on the ballot this year,
Yeah.
but to my knowledge, none of the MFCs are for the purpose of supporting the bond questions.
right.
I think they're all, as you said, sort of independent expenditure groups or specific candidates.
Any other questions on this?
Great.
Okay. And that takes us to item 5, which is an appeal of complaint BOE 03-2025, Tejas versus Forrester. And yeah, I guess it was my proposal, it's been adopted by the board since we took the agenda, that we could take a brief oral argument from the parties on that. And then before voting on what to do with the appeal. With that, who do we have here on the complaint? Hey,
Stephanie Theus.
hey,
And my name's Mario Willow. I'm general counsel for the office of the city clerk.
okay, and do we have anyone? Do we have anybody representing Mr. Forster? Or the like? And they received a copy of the agenda? Okay. So. Okay, so we've styled this as hearing from the complainant and hearing for the clerk, but if Mr. Forrester had been here or the campaign had been here, I would have heard from them as well, or the board would hear from them as well, since they're interested in this, obviously. With that, I've asked that the city clerk go first. Ms. Tejas, if you'd like, you could go first.
Fine.
Okay. Okay, please proceed then.
So again, my name's Marielle Willow.
What are we doing in terms of a microphone over there?
They're right here. See those green lights?
Okay, how about we change places with
Here,
Mr.
I have
Watson?
a backup mic.
Oh, we have a backup line.
Okay,
I'll go back over here.
Oh, yeah, that's.
apologies, I just want to make sure it gets captured for
No problem.
everyone online.
Thank you. My name's Marielle Willow. I'm general counsel for the office of the city clerk. To start out, I'd just like to give a little historical background regarding the rules of the Board of Ethics that we're operating under. Historically, the Board of Ethics received a significant number of complaints during election cycles. And many of them, in response to many of them, a motion to dismiss was immediately received regarding the board's jurisdiction over certain issues, which is the issue before you today. In response, the Board of Ethics and the city clerk created a screening process, which is when a complaint comes in, the complaint goes to the office of the city clerk. The city clerk reviews the complaint to determine whether the allegations fall under the jurisdiction of this board. And it allows the board to focus on the facts of the complaint in relation to the law that you're operating under. And Ms. Tejas exercised an appeal, her appeal right under that process. So Mr. Watson rejected the complaint for facial sufficiency. And Ms. Tejas exercised her appeal to this board, which is also in compliance with the Board of Ethics rules. So the Code of Ethics provides certain subject matter jurisdiction for adjudication before this board, and that can be found in the City Charter, Article 12, Section 3C. I believe that Mr. Rocha provided you all with background, the sections of the charter and the BOE rules that you need to decide this. And your jurisdiction is limited to matters covered by the Code of Ethics, the Election Code, the Open and Ethical Election Code, and the rules promulgated under the City Charter. So the procedures outlined require that complaints alleging violations are submitted to the office of the city clerk. And within 3 days of receipt of the complaint, the city clerk has to determine whether the complaint is facially sufficient. Generally understood, facial sufficiency means the complaint or document appears to meet the legal requirements. And the legal requirements for facial sufficiency of complaints under the Board of Ethics rules, there are 9 different items that are in the BOE rules. That's at section 5A3. And Mr. Watson found that the subsection G was not met, which requires that the complainant point to sections or parts of the charter or rule that the complainant believes was violated. In Ms. Tejas's initial complaint, Mr. Watson found that she didn't provide sections or parts of the Code of Ethics, the codes, which I'm referring to generally, which are the sections of the city charter over which you have jurisdiction, or the rules of the board that will promulgated pursuant to the codes. Ms. Tejas, I believe, is asking the board to review the substance of the allegations and not the strict form of facial sufficiency. And Ms. Tejas did cite multiple state laws and general ethical principles, but Mr. Watson found that the Board of Ethics doesn't actually have jurisdiction over those issues. There's state law and general principles. And so now before you, in this appeal, you have to decide whether you have jurisdiction prior to reviewing the allegations. And that's what Mr. Watson is requesting that you do on appeal. Thank you. If you have any questions, please let me know.
Can you comment on the addendum that the complainant filed and if that alters the view of the city clerk's office with respect to the viability of the complaint?
Yeah, so the procedure here was a little bit unusual. So in the response to the initial complaint, the city clerk asked Ms. Tejas to either submit a new complaint or appeal. The city clerk received the addendum and considered it an appeal. And then there was a subsequent documents that was titled appeal. And so in the addendum, there is one section that cites the coordinated expenditures, which is within the Board of Ethics jurisdiction. So I'm not sure how I think that's up to the board to determine whether the addendum was part of the appeal or the initial complaint. Procedurally, there wasn't a new complaint submitted. And so Mr. Watson chose to treat that as a appeal.
So can you address the substance though? Does the clerk's office believe that the addendum states, I would say states a claim or a violation within the board's jurisdiction?
So not Not exactly. It does state, it does name, it does talk about coordinated expenditures. But also in that addendum, Ms. Tejas says that she rejected the offer. And so there was actually no expenditure made. And so it's a little bit, I'm unsure if the board wants to treat that as something within your jurisdiction to decide whether or not it meets the definition of the board's expenditure or expenditures or not. But there's no, the rules require both the section and the reasonable detail and information that the board could rely on to make that finding, and that's not because she states that she didn't accept it. There was no expenditure.
Just one more.
Sure, go ahead.
And I'm trying to sort of piece together what Mr. Forrester's relationship was to, in all this. Did he represent another candidate? Was he an agent of another candidate? Do we know that
Yes.
based on the record?
I actually don't know if I could ask Mr. Rocha to share if he has more information about that.
On behalf of Aaron Griego, candidate for district.
And is it the same district where the complainant is running?
Yes.
So he was representing a campaign, right?
Yes.
So even if there had been an expenditure, would it have been coordinated?
That, well, I think would be for the board to decide, and that that doesn't technically meet the definition in the rules for the city clerk regarding what is a coordinated expenditure to support a candidate. And they essentially two campaigns and or Measure Finance Committee and another campaign have to like organize to support either one of them or a third party cause.
Thank you.
And any other questions as well? I'll have one more here. In Article, I guess, Article 12, subsection L. You're there, Ian?
Article 12, section.
L, the one that starts at the board finds upon majority vote.
Yes, yes.
Okay, and then under that 3.
Yes.
Okay, so that gives the board the ability to make a referral if there's a violation of the state election code.
Yes.
Did the clerk review the complaint and addendum versus the state election code?
No, the clerk did not do so in reference to whether the clerk believes there's a violation of the state election code.
Anything further from the board?
Yes, I have a question. So, the complaint, I'm trying to figure out what the requested remedy was. As I read it, the complainant is not requesting that any candidate be disqualified. Is that correct?
That's how I read it. I believe she's requesting an investigation into the allegations and to cooperate with an investigation.
Thank you.
Thank you, Ms. Willow. Ms. Taz?
Thank you, Chair Marks, members of the board. Thank you for the opportunity to present this appeal. So as was stated, the city clerk rejected my complaint for being not factually sufficient on the grounds that it did not cite specific sections of the city code or board rules. In this context, factually sufficient, I believe, means on its face, which was also discussed just by looking at it, has all the required information and enough facts to show a possible rule violation. And I respectfully contend that Mr. Peck, who was the acting city clerk at the time, who issued the letter rejecting it, because it was not rejected by city clerk
Watson?
Yeah, Watson. So as detailed in the letter, Mr. Peck, the city clerk, reviews all complaints for factual sufficiency, and the complaint was not referred to the Board of Ethics because it failed to meet the criteria. Specifically, it did not provide a detailed description of the alleged violation or identify the specific sections of the code that were violated. Instead, the complaint cited violations of New Mexico state law, which are outside the jurisdiction of Board of Education or Ethics. However, it remains unclear whether Mr. Peck reviewed the complaint for factual sufficiency, as no supporting documentation was provided. I'm a fraud examiner and auditor, so there's a saying in compliance: if it wasn't documented, it doesn't exist. And there's another saying in risk management and fraud examinations: to trust but verify. As no documentation of Mr. Peck's review was provided, how can one attest to the review procedure that it was complete? I conducted a factual sufficiency compliance review, mapping my initial complaint filings against Section 5A3 of the board's rules, which prescribes the 9-step checklist for determining factual sufficiency. The review's purpose was to evaluate the clerk's application of the checklist by aligning each requirement with my filings, verifying compliance, and documenting evidence that all criteria for factual sufficiency were met. I do have a copy of that if you would like a copy.
Yeah, we'll take it into the record. You have copies for everyone?
Mhm.
I mean, does the clerk have any objection to that?
No objection.
I mean. Okay. And Ms. Teos, if, in the interest of time, I would ask, I think you've talked about the factual sufficiency. I think that the issue that's probably the board's gonna have more problems with is the legal side.
Sure.
Whether the violation is something that you're alleging is within our jurisdiction, but if you could, for the benefit of, I think all the board members have read the complaint, but you can give a 1-minute summary of what the complaint
Yeah.
actually alleges, so that people who are just wondering, so all we're talking about is procedure and law, and we don't think anything is really mentioned, tell us.
Sure. I'm happy to do that. So the ethics complaint against Scott Forster's campaign manager for Aaron Grego is essentially around essentially the nature of the allegations was what I believe to be an unlawful attempt to influence the outcome of an election for Albuquerque City Council. Specifically, the offer to help retire my campaign debt if I would withdraw my challenge, contesting the finding that I did not have the required petition signatures to appear on the ballot. In addition, after I denied the acceptance of the retirement of my debt, they also threatened that if I proceeded with the challenge and won reinstatement on the ballot, they would file further lawsuits to remove me from that ballot.
Thank you. So if you want to address the legal, what ordinances or rules within our jurisdiction you think
Yeah.
violated by those
So-
two allegations, alleged facts?
Well, I have my notes here. So I believe pursuant to the Open and Elections Code, which is Part 6 Coordinated Expenditures, was a violation, as well as rules of the Board of Ethics and Campaign Practices 5A3G, which states the violation of the city's ethical standards for campaign conduct, even without explicit criminal charges. Offering something of value to alter the outcome of a nomination process is inherently unethical and improper under the board's rules and mission. My original complaint narrative and supporting timeline clearly show good faith allegations of unethical influence on the candidate qualification process, as well as the general ethical conduct city charter articles 13 and 16, which is the city election code and open ethical election codes, which prohibit acts that undermine transparency, fairness, or public confidence in the electoral process. The allegations here are contrary to the ethical standards established by the charter.
So that's. So in the charter, or which article?
That is in the city charter, articles 13 and 16.
So we're in 13.
Let me pull it up.
Mr. Chairman,
Yeah.
could you just read to us what in the charter you think was violated?
Yes, let me pull up the. I ran out of paper to print it, so I have to.
Okay.
The section 1, I believe, where it establishes the code of ethics with the fundamental, let's see.
Wait.
The proper administration of democratic government requires that public officials be independent, impartial, and responsible to the people, and interest of people, and it shall extend the official acts of elected officials and employees, as well as the official acts of members of the boards, commissions, shall also extend, sorry, hard to read.
So you're reading the declaration of policy at the start of the Code of Ethics, Article 12.
Correct.
Okay, we're all there then. Okay. We have, were you finished with your presentation? Okay.
Lastly, I just want to say, the city clerk has the authority to, promulgate their rules, especially filling in gaps. So if they felt that the original complaint didn't apply the right standards for meeting the 9 checklist test, rather than arbitrarily dismissing it due to a minor technical defect, they could have given it back for corrections. If this correction does not prejudice the respondent's rights, but it does frustrate the purpose of the ethics codes. And as we noted earlier, the clerk does have that opportunity to choose to treat an appeal as he clearly chose to treat it as an appeal, so he has the authority to make these choices under his discretion. And I just want to say again, I acted in good faith, supplemented my complaint within 24 hours with the citations the clerk requested. I filed the appeal. Again, this respondent has suffered no prejudice from this brief clarification. And I respectfully request that the board reverse the rejection. You know, we already know that the public trust in government is high, and skepticism toward the process to appear to offer only the illusion of fairness and oversight is widespread. And so a decision not to refer a complaint to the board based off of a technicality further risks eroding the confidence and fueling public ire toward our electoral process.
Any further questions?
Uh,
Mr.
Oh, sure. Ms. Tejas, what is the status of your attempts to qualify as a candidate?
Yeah, so I have requested clarification on the process on how the clerk chooses to reject petition signatures while accepting a qualifying contribution of the same individual. I have received a response that they are looking into it. So at this point, they are looking into it, and I'm waiting to hear back.
Mr. Quinn?
Can you address your addendum? You addressed number 3, which are the city charter provisions. But I think what I'm struggling with is the applicability of the coordinated expenditures provision to the facts that you've presented. Can you explain how that's a fit in your eyes?
Yes, I'm happy to do that. Let's see. The offer made by the campaign manager to help retire my campaign debt in exchange for withdrawing a lawful challenge, I believe, constitutes coordinated activity intended to alter the behavior. Of course, no funds were exchanged, but there was an intent.
So let's unpack it a little bit. Doesn't that provision require that an expenditure be made in order to be applicable?
Well, that would be, I'm not a lawyer, and I believe that would be a decision that the board would have to discuss.
Well, you did file the complaint and you cited that
Yeah.
provision. And do you believe that it applies, that there was an expenditure?
I don't believe that there was an expenditure, but I do believe that there was intent.
And what about the other part of that provision, the notion of coordination? Can you explain the coordination aspect with respect to the allegations you've made against Mr. Forrester?
Sure, there was coordination in that the campaign manager not only reached out to me and provided this offer, but also reached out to 2 volunteers of my campaign to provide the same offer.
And what do you understand coordination to mean under that provision?
That there was an effort to reach out and have some sort of collaborative discussion about it.
Thank you.
So. Did you have anything? Just follow up with that. So we're looking at the definition of coordinated expenditure. And coordinated expenditure means an expenditure that is made, 1, by a person other than the candidate or the campaign committee. 2, at the request or in cooperation, consultation or concert with a candidate, etc. And 3, for the purpose of A, supporting or opposing the nomination or election of a candidate, or B, paying for an advertisement for a candidate. So which, under that 3, which are you alleging that if this expenditure had been made, it wouldn't have been for an advertisement? So it would have been, how would it fit under 3A, supporting or opposing the nomination or election of a candidate?
Well, I believe that it was for goods or services.
Do we have more questions or?
Yes,
Mr. King?
I have one question. As it relates to your, the volunteers that you had, and maybe I missed this, but did Mr. Forster reach out to them?
Yes.
Okay.
Yes.
Thank you.
Me, but it's not offering to an improper inducement to a candidate, a competing candidate. I think a competing, certainly, and then the conspiracy to violate the election code consists of combining, uniting, or agreeing with another person to omit any duty or commit any act which would, by the provisions of the election code, constitute a fourth-degree felony. So it's the same things. Unfortunately, fortunately, unfortunately, candidates are not held to the same standard as elected officials. We have the clerk has an obligation to do his job without bias, without favoritism, and to follow the law strictly and not to accept any benefits. A candidate doesn't have that obligation. I mean, you could buy, apparently, maybe this is something that and then something the state should make a violation, but they haven't. The city, you've referred us to the general provisions of Article 12 and 13, which talk about transparency and ethics, and but they don't prescribe those. There's nothing in, when you get down past those, the colon at the end of the first policy statement that says there's no catch-all, and anything else that seems to be unethical. There's specific requirements for a campaign, and potentially, I'm not sure this would have been a coordination violation if you had taken the money, because it goes back, the coordination is to get somebody elected. It doesn't say coordination to get somebody off the ballot. But in any event, there was, you thwarted it by being honest and upstanding as under the facts as presented, assuming it's, we're all assuming for the purpose of today's discussion that the facts are true, but if we're not assuming past that. If we wind up holding a hearing, you'll have to prove those facts, and Mr. Forrester would have the chance to prove different facts, but assuming they were true, you thwarted this and as an actual coordination by not accepting the offer. So that couldn't apply. So I would be with Mr. Cuniff that while what you allege is something distasteful, it doesn't seem like it's unlawful within our jurisdiction. It might be unlawful within the state criminal code, but not the state election code even. So that'll be why
May I?
Yeah, that's fine.
Earlier I said that I didn't believe that there was an expenditure exchanged because money wasn't exchanged. However, I would like to amend that because I do believe that there was an expenditure, because an expenditure doesn't necessarily mean something has to be received. It just, there was any agreement to do so, which captures maybe an unfulfilled promise. So the promise was the expenditure in this case. And there was agreement, there was consultation, and there was a request between Mr. Forrester and between me, and not just myself, but two other of my volunteers or additional people that could be argued from your what you pointed out with the three pieces of the election code. And so even if nothing was ultimately received, I think the coordination itself is not necessarily in the delivery. And could be argued that the city charter and the rules state that there is an agreement to do so. So the language is kind of broad that might be able to allow you to accept that.
Okay. For the purposes of moving this on, I think what you've made is additional legal argument, which I will accept. I think if you had an actual facts that you wanted to make to say that there was an expenditure, you'd need to file a new complaint at this point, but we'll accept what you just said as a legal argument. There's a motion before the board to overturn the appeal and bring it back for further?
Or, what did I say? Overturn the clerk's ruling.
Overturn the clerk's ruling, bring this back for, as a complaint before the board. Is there further discussion on the motion? Seeing none. All in favor of the motion to overturn the clerk and also incorporate the addendum into the complaint, signify by saying aye.
Aye.
Opposed?
No.
No. It looks like the motion carries. And we will
We'll see you back here.
yeah, we'll be back here and so the next step for them to submit briefing, or what do you know what the next step is, Mr. Watson?
Mr. Chairman, members of the board, there are procedural rules in the board's rules. I suspect we will work with the parties to set a procedural schedule for the matter in accordance with the board's hearings, and it can move forward in accordance with that schedule.
Okay, thank you. Thank you, Ms. Willow. Thank you, Mr. Hess.
Thank you.
Okay, we have item 6, Office of Internal Audit update.
Yes, sir. Thank you. This is Vanessa from OIA. Cristobal, may I trouble you to place the ability to share screens?
You should be good to go.
Thank you, sir. And just for confirmation, can you folks see a PDF?
Can you zoom in?
Yes, absolutely. Is
But yes, we see it.
that better? I'm sorry, is that better?
Oh. That should work.
Let's see. I'll move along absolutely as I speak to it. Okay. But yes, thank you, Mr. Chair. Again, similar to our last meeting, we went ahead and put together another high-level overview status of the QC examination. As you folks know, the qualifying contribution period for the mayoral and the city councilor candidates has come to a completion. That being said, the two tables represent the status of all candidates that pursued public financing. The first table represents those that qualified for public financing, and the second table represents those that either shifted from public to private financing or either entirely dropped as a candidate. Now, our office, OIA, has met our 5% requirement of QCs to verify for each publicly financed candidate. And so what we'll do now is transition to our final report. I will say, sir, this go around, we did identify 3 QCs of monetary concern. This is the first time. So specifically, we identified one contributor that basically claimed to have not donated the entire $5. She rather gave pocket change, no more than a single dollar. Another contributor did not recall donating the $5 at all. And another contributor denied making any donation whatsoever. Now, with these areas of concern, our office performed what we call extended sampling, meaning for every booklet where we identified these contributors, our office examined the entirety of the booklet. So, for example, if one contributor was identified within booklet number 1, and the booklet contained 10 total contributors, we verified the full booklet of contributors in an effort to perform our due diligence and see whether there were additional areas of monetary concern. And for all these 3 noted instances, we of course relayed to the city clerk, and to confirm, we did not find any other areas of monetary issues. That being said, sir, we always, try to keep it very high level for you folks. We'll now shift to the final report, and now we respectfully open for questions.
And Mr. Watson, the 3 violations that Ms. Meske mentioned, those are the subject of our next item on the agenda, correct?
They are.
So let's hold off on those. Are there other questions regarding the status report from the internal audit? No. Okay, thank you. Please stay on connected for the next item, Ms. Meske.
Yes, sir.
All right. Okay. So we've got Mr. Watson, discussion and potential action on the city clerk's request for an investigation. And we'll hear from Mr. Watson, and we'll hear from the campaign if they choose to respond.
Mr. Chair, members of the board, should take the mic. Just some context to start out. In 2021, we had 2 complaints from the public, which uncovered initially a small number of violations of our code, which led to another complaint, which led to an inspector general investigation, which uncovered significant systematic violations of the city's campaign finance code by a mayoral campaign. In response to that election cycle, we adopted a number of reforms to protect the integrity of the city's public financing program. Foremost among these has been the ongoing audit conducted by the Office of Internal Audit. In 2023 and 2025, we have now done a door-to-door audit of a percentage of qualifying contributions each year to ensure principally that qualifying contributions are signed by the person who is named on the contribution, and that the person named actually did contribute the $5 associated with that contribution. Internal Audit, in the course of its audit this year, has occasionally identified issues, for example, out-of-date addresses, but our primary concern does remain the financial issues that the people who are on the QC and forgery issues, frankly, that the people who are identified on the QC actually signed it and that they actually contributed the $5. In the request for an investigation or expanded audit before you, the Office of Internal Audit did submit an interim report to our office on July 28, which in our view identified 3 significant concerns. First, it identified a contribution by a contributor, last name Atkinson, wherein Ms. Atkinson stated to Internal Audit that she identified pocket change that did not total more than $1. The representative collecting that contribution was identified as Daniel Leyva, who we believe is the candidate. We're unclear if there's a volunteer on the campaign also named Daniel Leyva, but we believe that's the candidate. There was also a contribution from a contributor last name Smith, who did not recall making the $5 contribution. That contribution appears to have been collected by a volunteer. There was also a third contribution from a Mary Tapia, who stated that the signature on the form was not hers and also denied making on any contribution. The representative collecting the contribution was identified as Alexi Leva. We provided our request for the investigation to the board and the campaign. The campaign responded to our request and addressed the three issues. With regard to the Tapia qualifying contribution, they provided a statement both from the voter and the campaign, wherein they identified that the name of the wrong voter was written onto the qualifying contribution, and the contribution was actually from a Mary A. Tapia and not a Mary H. Tapia. Regarding the Smith contribution, the campaign provided a statement wherein he now recalls making the contribution despite previous statements to internal audit that he did not. In regards to the Leva contribution from Atkinson, the response from the campaign is that it appears undisputed that the contributor did not make the full amount of the contribution, but rather that another customer covered the difference because the contribution was collected outside of a Walmart. I will say, while we are still learning from our ongoing audits conducted by the Office of Internal Audit, all instances of issues identified by internal audit do not raise the same level of concern. Volunteers for campaigns are a challenge because they are not agents of the campaign and may make errors. And the campaign's responses on the Tapia qualifying contribution and the Smith contribution facially address the issues identified. We do still have my office does still have some concern regarding those contributions, which may be addressed through the expanded investigation. I will say at this point, the Atkinson contribution does remain concerning. The response from the campaign appears to be that additional violations may have occurred. We are also concerned because it does not appear that it was collected by a volunteer, but rather the candidate himself. I will say, in addition, that we've taken a cautious approach to these issues. I did certify the candidate to receive public financing despite these issues identified by internal audit. I did not view these at the time as final determinations, and we have also not filed a complaint against the campaign at this time. We are seeking additional information, and we do want all the campaign to have a chance to see the evidence gathered and to respond to any evidence gathered. And so in light of the concerns and in the interest of taking an incremental approach, we are requesting a special investigation by the Inspector General. We would ask, I think at this point, that the Inspector General's office an additional 5 to 10% of the campaign's qualifying contributions, with a weighted focus on the contributions gathered by the representative identified as Daniel Leva. If that is not ultimately the candidate, that may change the nature of any violation. If that is a volunteer of the same name, so be it. But that is our request at this time. I would stand for any questions.
What's the proposed timeline of the investigation? What would be the best case scenario end date?
I think we would defer to the Inspector General's office, and I believe they are here.
Good morning. I'm Interim Inspector General Peter Pacheco, and regarding the timeline, I would hope maybe 3 to 4 weeks. If we're doing a small sample size, we are a small office of two investigators and myself, so we do have a lot of work that we're doing also, but we could try to expedite it as quick as possible. And basically we'll be doing what internal audit did. We're going to ask for if they contributed, if they paid the $5, if this is their signature, but we'll be doing it for people that they didn't have in their list.
Other questions? When when internal audit did some additional sampling, so they said they did $3. How many more contributions were sampled if there are $3 sampled? Is it 30 or I mean 27 or is how many in the book?
I think it's 38 total.
But so they did 27 more?
I believe that's.
Vanessa, are you still with us? Can you?
Yes, that's correct. So, sir, when we performed our extended sampling, it was about 38 more individuals. And with those individuals, we did not identify any areas of monetary concern.
And Mr. Watson, that doesn't change your concern that there's potentially systematic issues with the campaign?
It does not, your, Mr. Chair and members of the board. I think the concern is twofold. First, we do just, I mean, we have historically and for the board conducted entire hearings over single contributions. And so I don't think there may not be systematic violations. We are just very concerned. I think that one of these does appear to at least be from the candidate himself. And so, and I think the other concern is also evidentiary. I think we would like to, we would like to be prepared to present evidence before the board if necessary. And I was not necessarily of the view that internal audit was going to, was going to be prepared to present each contribution as an evidentiary matter. And so I think, and I think we are trying to be reasonable about our approach to this, and we defer to the board's judgment on this, frankly, Mr. Chair, is that I think an additional 5% sample weighted towards this collector would address our concerns, and that there may only be this single violation, which if we could then work with the campaign to address. If it does identify additional violations, assuming the board is willing to proceed on that, then we can be prepared to present that.
Okay. Let's hear from Mr. Leyba.
Good morning.
Oh,
Sorry, I don't know.
You're good. Sorry.
Thank you so much.
Mr. Chair, member of the committee, or you're right, or commission.
Good morning, can you hear
Can you
me?
guys hear us okay?
Yeah, we can hear you, and I think you're sitting in the right place.
Thank you, Mr. Chair. Members, just given the
Hey, do you want to identify yourselves, please?
Damian Lara, on behalf of the Daniel Labor Campaign.
And I'm Iris Calderon. I was actually a volunteer and I was the one that would audit when the contributions would come in. And so that's why I'm here as well.
Okay, what was your first name? ma'am?
Iris, IRIS. So it's like
Okay,
Iris in English.
Calderon?
Calderon, yes.
Okay, so we're not here to take evidence. I think if the board member had a question, I'm not going to stop them from asking a factual question, but we're here essentially for legal argument.
Okay.
I understand you're gonna explain what happened with these, and we'll listen to it, but we're not swearing anybody. I'm not taking witness testimony today.
And no evidence either?
I'm not taking evidence. We're not here. It's not noticed for a hearing.
Okay.
So no, none of
We-
this. That's that. Yeah,
We appreciate it.
and so, Mr. Lara, let's just hear what you have to say about why there
Yep.
should or shouldn't be a further investigation.
So I'll quickly respond to the county clerk. I think they were satisfied with the unverified contribution, Raymond Smith. This contribution was collected at the No Kings rally. When we were able to present him with the book and saw my face, he recognized that, oh, that's right, I do remember. He did subsequently send an email saying, yes, in fact, I do remember giving the $5 contribution and having made that contribution. As mentioned, Marriott Tapia.
When you say my face, you collected it yourself?
I collected it, and then, again, as Ms. Calderon said, sometimes because you're trying to get more than one person in a rush, you don't fill out the entire book so that you don't miss out on a contribution. Maybe, better training on our parts, or trying to lose out, willingness to lose out on contributions when there's a crowd or you're trying to do things of that nature. I'll put that aside. Marriott Tapia, again, was a clerical error on our part. Again, the signature was hard to read. The A kind of looked like an H. We understand that probably that in fact doesn't need to be thrown out. We did verify the new address. We had been using Vote Builder to go through all of these after the fact. Sometimes that unfortunately is also not updated. The contribution for Ms. Gigi Atkins, we did reach out to her. We asked her about the signature. She felt that was her personal contribution, that she was given that money by somebody else outside of the campaign that then made that her personal contribution. She, once again, read the form. We said, why did you sign this form? She's not denying signing the form. There is a clear notice on the form on the contributions that says, notice to contributors. And she said, because that's what I had. Somebody else gave me the money to me. That became my money. And so I was able to complete the $5 contribution. So again, I believe that it's warranted. I do want to address the city clerk's concern, again, because we did have certain volunteers coming in that didn't completely fill out the book. It was the responsibility of Ms. Calderon and Mr. Leyva to verify signatures, addresses through Vote Builder, through a sort of secondary screening for all of these things. While he did not personally collect the contribution, he did sign the book because he verified the name and the $5 and counted that information and looked up the information on the on Vote Builder. We are, glad to hear that an additional 38 something. So that audit essentially has already been completed. 38 more signatures or books have typically been done with no further issues found. I understand that there is, from the perspective of the city clerks, out of an abundance of caution to move forward, but proceeding with an investigation merely out of an abundance of caution unduly prejudice the campaign. If it's going to take another 4 weeks to go through this, we are on a very strict timeline. It's going to do irreparable harm to the campaign. Just having this hearing, which we understand isn't a complaint, has already caused negative harm. We've been reached out by different people about why has there a complaint been filed. At that point, again, I'll apologize for my ignorance. It was clarified last Friday that this is not a complaint. When we're looking for volunteers and contractors, they point to the fact that there is, a hearing set, that there's an investigation going on, whether or not we're actually going to have the money, or if it's going to be taken away, if we're going to be able to meet obligations. And again, there is no evidence here from the contributors' perspective that they did not sign or that they did not contribute that information. And I would strongly ask this board to take into consideration that the Office of the Internal Audit already did an expanded, if they initially did 22 or 23, and they did an additional 38 with no further issues on that entire book, that in itself shows that this is not a systemic issue. And so, again, we did not commit any fraud here. We did not forge any signatures from any of these people. All three of them acknowledged signing that book and having had made the contributions. Therefore, there is no sort of finding of fraud or violations of the charter. And again, proceeding with an investigation out of an abundance of caution is not only has a chilling effect on our campaign, but the practical effect is that public financing is not something that's attainable for most people. You saw the reports. This is one of two campaigns that are not incumbents that were able to do this. Every other single campaign had the benefit of doing this before, had the benefit of being an incumbent, had the benefit of knowing the practices and how to do those. This is something that we're learning for the first time. Yes, we made a mistake with the address, and I thank the city clerk's office for understanding that mistakes were made. And just like mistakes were made, on our campaign, the city clerks didn't put our email addresses correctly. They corrected that. These are honest mistakes that do not amount to a fraud or a willful violation of the ethics codes. And we weren't aware that another 38 signatures were done. We're happy, I guess, that they were done sooner rather than later, because again, another 4 weeks of uncertainty, just the perception that we violated is going to hurt our campaign. And it already has. So with that, I'm happy to take questions, members.
Mr. Cliff?
Could you walk me through the explanation for the Mary Tapia contribution?
Sure. Do you want me to?
Yeah, all right.
Is it okay if I do that?
So for the
Mary Tapia, so what happened is we had a volunteer, they came in. So early on, what happened is we had our volunteers go out. They would come back and we were realizing that sometimes the addresses were not legible and we didn't want to be rejected because addresses were not legible, or simply some volunteers would come with the money and with the signatures and maybe just with the not the complete name as it was in Vote Builder.
So what was happening early on, because we were collecting signatures, petition signatures, and the book, we were using the filled out signature block on the petition signature to then help fill out the rest of it and make sure that everything was legible.
Right.
So just understand, so you would approach a voter and present this form and then just have the voters sign it and then fill in the rest of the content later on?
So it would just depend. So for example, sometimes we would go to somebody's home and they were like, we're in the middle of dinner. Like, I'm gonna go ahead and sign for you. I'm gonna give you the $5. I'm signing your petition. I'm signing your book. Please go on. Other times we would if someone would open their door and they would be happy to have a conversation with us and they would be happy to fill everything out. So it wasn't, even though we would, on our end, we would try and get as much information as we could right then and there. For some people, they really just wanted to close their door and tell us, here you go on your way. So it's not going to be the same for everybody. But in the case for Mary Tapia, what happened, a very lovely lady, she signed for us. She signed for us as Mary Tapia.
The signature that we see right here.
Yes, the signature you see right here. So she went ahead and she signed it. What happened is she gave us the contribution. So then when we got the notice that Mary Tapia had not signed, what happened is, oh, let me step back. So then the person who actually collected this, the person who collected it is Oscar Villanueva. He was one of our volunteers. When Oscar Villanueva came.
It says Alexi Leyva on here.
Yes, oh, I'm sorry, no, Alexi Leyva, you're right, Alexi Leyva.
So when Alexi Leyva brought it, what we did is we went ahead and we got Mary's signature. So what we did, we opened up Vote Builder. And on Vote Builder, we looked for a Mary Tapia, and one Mary Tapia was in the district. So we assumed it was Mary Tapia who was in the district. So we filled it out as Mary Helen Tapia. So then when we realized, when the clerk's office sent, we're concerned. We also were very concerned. So that very same day, the same day we got the letter, we opened up Vote Builder again. And we said, okay, what could have happened? So when we opened up Vote Builder, we realized, okay, there are about, I believe there was like 4 Mary Tapias. So what we did is we said, okay, we know it's not Mary Helen Tapia because she already said it's not her. So then we went to the next Mary Tapia, where we found Mary Ann Tapia. We went directly to her home. And we explained, we said, Miss Tapia, would you be able to confirm that you did sign this booklet? And she remembered very well. She said, yes, I did sign this. I did give the contribution. So that was the error that was made. And we do take responsibility for that.
Whose address is this? 55413 Vista Cielo. Is that?
It's Mary Helen Tapia's address, not Mary Ann Tapia's. And sorry, just for people who may be watching on the broadcast, can you explain what Vote Builder is? Oh, sure. Vote Builder, and maybe do you know how to explain it better than I do? I mean, for Vote Builder is a program that I don't have. What was explained to me is basically it's a place where you can identify voters. And so we were able to identify voters from District 1, or you can expand. So it gives you any registered voter's name. And it gives you some more information, like what party they're registered, their age, their phone number.
Did Mary A. Tapia also sign the candidate's qualifying petition on the same visit?
I believe so, yes.
And did she have to write her address on that?
I don't know. I don't have that one.
For an address?
Yes, it does. So they typically would. This was 6/25, so that probably did happen.
Have you gone back to see like what address is entered next to her name, if any?
So
these
these turned
up.
Yeah, so unfortunately, we didn't have the foresight to make copies of those, and we turned all of those in to the city clerk's office.
So you don't know what address was on the petition for?
No.
Yeah.
No, but we're assuming it's the address on the affidavit she signed for us.
She signed an affidavit
Yes, she did.
under oath?
Yes, she did.
And she put an address of 1621.
The affidavit she signed states that she did sign the petition, and she does give us her address, her correct address.
Did Alexi Leyva sign an affidavit or declaration about her involvement in collecting the signature?
He
We
did not.
We
but
did not ask Alexi Leyva for an affidavit. Was I clear?
Yep.
Thank you for
Other
that
questions?
We have another question, and it's about Gigi Atkinson. So if I understand the presentation, this qualifying amount is collected at a Walmart store, is that right? And Miss Atkinson didn't have enough money in her possession at the time, is that right?
So yes, so what this is with Miss Gigi Atkinson, just to clarify, it was collected at a grocery store. We also went to her home directly, and we introduced ourselves, and we said, Miss Atkinson, we have some follow-up questions for you. You did sign our booklet saying that you contributed $5. Did we understand what you were signing? Because we're basically being questioned on this. And so she explained to her, she said, yes, I did. And we asked her, why did you sign? She said, the reason I signed is because I had pocket change, but there was another customer and they gave me the difference. And she also signed an affidavit as to that.
Be her money then, right? Like if somebody just handed her the money so that she could use it to make a qualifying contribution. that doesn't transmorph it into using her own money. She used somebody else's money.
Right, so legally, I mean, I did not look into the case like that.
Mr. Lara, do you,
So,
lawyer question?
yeah, I know so how far removed is it, right? So I think the last instances that we had here that sort of gave rise to all of this, it was the candidate's spouse who gave a person the money, who then in turn gave the money to the campaign. That is not the situation here. How far removed are we going to start getting on that campaign? I can clearly see, there's a distinction between what is on the notice. Did you receive anything of value in exchange for this, including giving a contribution? She said no. If I work and I make money, is that my money or is that my boss's money? If I have employees and I give them a paycheck and then they later on come and contribute to my campaign, do I say no, don't give me money because actually that money is my money, right? If somebody has change or gives money, so in this case, I would go back to her statement, which is that she did give the money. She signed the book. When asked again by us, she did sign an affidavit confirming that she believed that that was her personal money, and that while she had it at the time, she was able to get the difference to provide the campaign. So in this case, I would argue that yes, in fact, it was her personal money, that it did transmute, and that the campaign had nothing to do with that interaction.
The petition or the signature gatherer wasn't present for that interaction between Ms. Atkinson and whoever provided the balance of $5.
He was. So we did, on this one, we were able to speak. We did reach out. We're trying to figure out who the, and it was, I believe, this was Oscar. This was Oscar, who again, because was trying not to miss out on different people, would kind of be asking different people, and so wasn't always filling out the things. We have since corrected that, but he doesn't remember who the customer was. And unfortunately, Ms. Gigi Atkins doesn't remember who the customer was either.
So who collected the $5? Was it Oscar or Daniel Leyva?
For Miss Gigi Atkinson,
Yes.
that was Oscar Villanueva. And Miss Gigi Atkinson, we spoke with her and she said she remembered him clearly because of his height and just the way he looked. And she had a little puppy, a little pug. And so they talked about the pug because it was just recently adopted. So Mr. Villanueva, if needed, he could also testify about the exchange.
My question is why is Mr. Leyva identified as the representative collecting the contribution? And is that his signature next to his name?
Correct. So yes, that is his signature. And the reason his name is on there, what would happen is the following. Once we would have volunteers, they would go out and help us. And they're all volunteers. Nobody's paid. And they're doing us the favor of helping us. They would come back and sometimes, like I said, a book wouldn't be signed or a book didn't have the address. So we would do a second audit. The second audit was usually done by myself, done by Daniel, or done by Donna. There was three of us. We would usually try to look and we would try and fill in the booklet. So that's why Daniel's name is on there.
What date was the campaign certified for public financing?
I'll defer to, it's been a while. I'll defer to the county clerks for when that was done. But we haven't spent any of the money because.
Has the money been dispersed to the campaign?
It has. So we do have I believe all of the money and stuff, and we have contracts lined up to sign today. If the committee chooses that this does not rise to the level of fraud, then we're able to execute those things today. We're just, again, spending another 4 weeks in limbo with less than 80 days to go seems like it just unduly prejudices the campaign, especially if the Office of the Internal Audit has already done more than 5%. If my numbers are correct, 5% is 23, and they've done, as they testified earlier today, another 38 of full books, which would, again, I'm assuming, cover the signature concerns that the clerk has. with no further issues found again. You know, I'm not an auditor, but sometimes this happens, you know, sometimes you just get unlucky and you find one that was, you know, was bad. But I also ask you to weigh, you know, the totality of circumstances. This is why we also collected more than 10% of the required signatures, right? Because we did have other contributions that were rejected for being out of the district, other things that were because they weren't completed completely, and we ourselves voided several contributions that came back because we couldn't verify them. And no offense, but again, you know, when you're new, I ran a campaign before, I've never done public financing before. You know, but not that is an excuse. We did training. We tried to follow the advice of the county clerks as best as possible, but we can't do this without volunteers. It took 30 people minimum to help us at different times, and we try to train them as best we could. But you know, I think the what's been, again, we appreciate the concerns. And we appreciate that the county clerk is no longer concerned with two of the three. But we also believe that this isn't, you know, again, proceeding with an investigation after an additional 38 have already been done with no further issues, out of abundance of caution, that's unduly prejudicial to the campaign. And it's going to cause irreparable harm if we have to wait another 4 weeks to continue investigating or to continue to put things in limbo. We don't know whether or not we'll have to pay that money back, whether or not, you know, we feel very confident in our contributions. As, you know, the Office of Internal has said that there's no further issues. It's the perception that's going to be out there. Every time that you continue to put something on the agenda with our name on it, it's an opportunity to go to the Albuquerque Journal or to have one of the blogs say that, hey, we're still under investigation. And just saying we're under investigation is enough to turn people off. You know, that's the headline, and we're gonna lose voters. We're gonna lose people.
I just have one more question, and it's for both of you. And what is the standard here? Like, in order for this to be a violation, if it was an honest violation without any sort of fraudulent intent, is it okay? Or are we talking like strict liability, where either it's a violation or
Mr. Chairman, members of the board, I would like to address some of the issues the campaign has raised. I'll address your question, your immediate question first, but I think it all depends on the facts and circumstances. I think we are very attuned to and focused on violations committed by campaigns' designated representatives. And so it really depends on who gathered the contribution. This contribution was signed, it appears, by the candidate himself. There's been discussion today that the campaign may have had a practice of having the candidate or their designated representative sign unsigned contributions, which is extremely concerning to my office, because that is in and of itself more violations of our code, and I think warrants actually the investigation that we are asking for. So I think it really does depend on the facts and circumstances. An inadvertent error may not necessarily warrant fines. It may warrant a reduced fine. I don't know that it's a strict liability standard. I don't know that we've actually had express rulings on that issue. You know, the Board of Ethics has treated different types of violations differently in the past.
And again, I would kind of echo that and supplement it that this is up to the board. Is this, as you mentioned, an honest mistake? Is this, and we are saying that it is, right? We're not trying to do anything here. We're not forging signatures. We're not doing that. It's a procedure versus substance issue, I believe. You know, whether we are technically following everything, we could have been better. We understand that. We were forthright and honest with what we have been presented. And we have no malicious intent, nor intentionally tried to do anything that would be in violation of the laws or anything that would amount to fraud. You know, and again, every single campaign volunteer had rejected qualifying contributions. We did as well. That's why, you know, when we were trying to figure out how to do this, we were told, get more than you need, because some of them are gonna end up being thrown out, whether because they're incomplete, whether because they're out of jurisdiction, whether because, you know, a whole host of reasons. And so I would say again that this is something that the committee can treat as an honest mistake. And perhaps, you know, we know this, but again, as Chair Marks indicated, you know, this is maybe something that can be promulgated or provided during the trainings, so that we can have a trainer. You know, the city clerk's office didn't have that. They gave us general information of what we were supposed to do. We then provided that training to our volunteers, and we try to supplement that. And we did the best we could within the color of the law. So I would say that no, it does not, an honest mistake does not rise to the level of warranting further investigation.
I have two questions, or just a point of clarification on the Miss Atkinson's donation. So do we actually know how much she actually donated and what the balance was given? And I guess my question is, we have no idea who this other individual was that gave the balance of the monies.
So when we spoke with her, she did not recall specifically how much, but she did indicate that the customer made up the difference. She did not remember the customer who gave it, and neither did our volunteer.
And when you say customer, that's a customer of Walmart?
I believe so. That's what she said. I maybe, you know, she was very adamant that it was her money, that was in fact her signature. And that, you know, when she was initially asked, she said, well, how much did you? She said, this is what I had. She said, well, why did you sign? She said, because I gave the full amount. And we do have her statement that has been provided to the city clerks from, again, just the notice to the contributor is very clear. And she was aware of that. She signed on the form once again, saying that that was her personal money, and that was in fact her signature.
Thank you. And then I want to revisit Ms. Tapia as well. I guess and I apologize if I missed this, but why, when you first went to the software program, there was only one that showed up, and the second time there was 4?
Because the first time what we did is we put District 1. So you're able to, the program, you're able to put just District 1, City Council District 1. And so that was the person that came up, Mary Tapia. The second time we did a broad search of all Mary Tapias. So he gave us an entire list of every single district.
And is it standard practice to look up just in that single district, or what's kind of?
I guess that there should be best practices through doing this. That's what we found. Like if we didn't find them in District 1, then we knew that they weren't a qualifying contribution, and so we would get rid of them. Unfortunately, the name is just so almost exact that a Mary Tapia came up. That was the Mary Tapia that came up. The signature is very clearly Mary Tapia. It just happened to be the wrong one, and we were filtering out again because we didn't want to have too many qualifying contributions that would then be rejected, because we also had to, we had to plan, we have to collect 25 qualifying contributions per day, otherwise we wouldn't make it. And so, unfortunately, 5 weeks seems like a lot. It's not. And so we just, the time crunch to do this was also a factor. We were trying to be as efficient as possible. Maybe that is not the best practice, but we also didn't have the benefit of paid consultants. We didn't have the benefit of, of the experience of other, of having done this before with like the incumbents do. And so, again, there was no training from the city clerk's office or a trainer that we could have said, okay, myself, the candidate, other representatives of the campaign can learn all of this stuff, and then we can really be good about training our volunteers. We didn't receive that, right? We received very general information about what we should do. And the only thing that we could do to think of was to pay for Vote Builder. We had to pay, very early on from the campaign, $500 to use this software and trying to use it as effectively as possible. But we also learned that software system and database is not accurate.
Well, Mr. Watson, I want to add a question for you, and then I think I have the one that's bothering you a lot, Atkinson, or the one that was bothering you a lot at the beginning of this discussion, Atkinson, the grocery store one. Can you point us to any authority or precedent that really addresses the issue of when all or part of the qualifying contribution comes from an acquaintance of the contributor, and somebody not associated with the campaign? I think, as Mr. Lara has pointed out, when this stuff has been sanctioned in the past, it's been the campaign basically taking from one pocket to the other. Here's the $5, doesn't really cost you anything. Is there any authority talking about when it comes from an acquaintance of the or a third party unrelated to the campaign?
Our rules only allow one specific instance, and that's family members.
Where's that?
It's in the code of, I can find it, but.
It's
So-
It's in the rules by the city clerk.
the city clerk rules, okay.
And I will say our rules are very clear, members of the board, that the person who signs as the collector is supposed to be the person who
Right.
actually collected the $5. So I'm concerned that the campaign is saying here today that they had a practice of receiving unsigned qualifying contributions and then having people simply sign those. So it's on page 21 of the city clerk rules,
And
subsection 7.
no, that's 7. That's not what we're asking.
Part 13,
What?
A7.
A7.
Page
Page
A7 says family members may make a qualifying contribution in form of a single check or same credit card or cash. It doesn't say anything here that if I was at some, if I was sitting at a table at Denny's and labor came along and
Right, basically, the situation is not a take a penny, leave a penny jar, right?
well,
No, I mean,
I'm not sure of the analogy. I'm just saying,
Oh.
it's you got two people not related to each other. They're sitting at the table, and the candidate comes over and says, either one of you in District 1, oh, I am, would you get $5? Well, I don't got it with me. Joe, would you loan me $5? Or
we don't,
that happens.
I don't think we allow that.
You don't think that?
No, I don't think it's allowed by our rules. I think the person who submits the $5 it's supposed to be their $5.
Well-
If it's family members, family members can use the same account, but I don't think that's allowed under our rules.
So, Mr. Chair, members, so just canons of construction this is a permissible activity that family members make. So you're allowed to do this, whether you want to or not, that's fine. But nowhere in this statutes, at least not from number 7 or anything that I've looked at, is there's explicit prohibition on the activity that Chair is asking about. Nowhere does it say members may not provide this information or a qualifying contribution shall not be given by a third party, right? That's the language we're looking for that would prohibit the activity that you're specifically asking.
Or it's a gift. I mean, what you have is a gift or a loan.
Correct.
By a third party.
And that becomes yours. This is not like you're saying community property where the candidate was giving the campaign. And this is a may, and there is no language that explicitly says shall not.
So if I can steer the conversation a little bit back toward process. So the Office of Internal Audit, as the clerk told us, since 2021, the Office of Internal Audit has engaged in a process of constantly checking QCs and petition signatures so that we don't have a bottleneck of having to check them all at once and identify some huge ongoing problem. So the Office of Internal Audit sent out its updates, and then the clerk certified this campaign for public financing. And so my concern is more with the public's interest in finality, in that we had a certification of public financing, and also the interest in public confidence in elections. So we had that, and under those circumstances, are there grounds for kind of reopening the discussion after we've already had all of this process?
Well, I think it's very poignant, because you're right. The Office of Internal Affairs, unbeknownst to us, already did an expanded audit and found no further issues with any of the stuff. So that's already been done. So Sharon, Member Capri, you're absolutely right. I think the finality today is what's in the best interest of public. And given the fact that the Office of the Internal Auditor already looked at these three, did an expanded of an additional 38, and found no further issues. So we would agree with you that finality now is in the best interest of having both transparency as well as finality for the candidate to move forward.
No, I'm gonna address that, and I don't know if it's my place or not, but Mr. Lara, nobody's under oath, but your campaign has basically made an admission that you violated the regulations, and from what I've heard today, and if we have a hearing on it, I still have an open mind for the other way, but it sounds like it was all in good faith that you tried to make sure you were only putting in QCs for people in the district, and you were wanted to clean up addresses and so forth, but you did it wrong from what you told me. The person who was signing as the collector should have been the person who collected it. And then if you wanted to add whoever verified it, it should have been somebody else. But you had a practice of putting down the name of, Ms. Calderon or the candidate, the person who did the checking of the QC as a collector, and that's a violation that you've admitted to. I would say if you want finality here, maybe you and Mr. Watson should go into some negotiations and maybe agree to pay a fine to deal with that and get it off from over your head, because I'm guessing he's going to come back with a complaint based on that, and it's just going to continue on. You've admitted, and I heard you admit conduct that was maybe well-intentioned, but you shouldn't have done. Personally, I'm less concerned about the three, although you've given explanations. You basically the Mary Tapia, you were trying to rehabilitate that one, but you actually put in a QC for somebody who was not in the district, and say, well, that doesn't count. And this board doesn't have the ability to take away your public financing. We can fine you. So if we get a complaint back about either any of these QCs or the fact that you were misidentifying the collector, the outcome will be. Am I wrong about that?
Mr. Chair, that historically was correct. Following the revisions in 2021, revocation of public financing is actually a remedy the board can now take. And I think my concern actually here today is now that I'm not aware of the full scope of potential violations which may be at issue by this campaign, and revocation may be a remedy the board may need to consider down the line, and I think the campaign's stated practice of accepting qualifying contributions which were unsigned by a collector and then putting their names on the qualifying contributions is significant. And
It-
that's,
It is significant, but,
Chair?
if we. Uh. Uh. Is there?
Well, wasn't the potential motions we could take right now is the board authorizes the investigation or rejects the request for an investigation.
There's a third motion. Motion to table.
Oh, okay.
We could table it and. Tell the campaign that, you guys are gonna need to open the kimono and.
But to-
Work something out.
To allow them to voluntarily submit to more auditing or?
Or something, you've got, because. To satisfy,
Well, right,
so yeah, there are three options, we can either authorize, reject the request for an IG investigation, which doesn't prevent the clerk from coming back with something new. We can authorize the investigation, or the third one is a table
So maybe we can have a brief recess and maybe we can confer.
Are you okay with that? I like that idea. Normally I don't like horse trading, but I think as Ms. Caffrey has noted, there's, and you have noted, there's some benefit to certainty and. You guys want to talk for 10 minutes?
Yeah, we can talk.
Okay, we're going to take a recess until. 12:15.
Sure. We have to be out of this room by 12:30.
12:30, okay. What else do we have on the agenda?
I think this is it.
Okay,
Just wanna.
yeah,
Point of interest, before the meeting adjourns, you may want to set another meeting because with respect to the previous matter. That is now, the complaint that has now been referred to the board, it has to be heard within 30 days,
Okay.
which.
well, if you guys talk about that and
Yeah.
we'll,
Yeah.
Mr. Roach and Ian will.
Our
deal
next
with
meeting
it.
is September 10th.
You guys go talk.
So-
We're in recess for till 12:15 and now concentrate the mind.
Yeah.
15 minutes, take action.
Ethan, there's a room right here. We can. Oh, good. I didn't like.
But we're live, okay, we're back from our recess and we were live on YouTube Gov TV. Mr. Watson,
Chair Marks, members of the board, we have met with the campaign, and I think at this point, what we'd like to propose is that the board do table this and reset and have a special meeting in a week. And we are going to attempt to work with the campaign to and the Office of the Inspector General, if they are also available to submit to a voluntary investigation of their campaign to facilitate identification of the scope of the issues. And if we can come to an agreement about that, that'll facilitate resolution of any violations. If we can't come to an agreement, I think we would have the opportunity to come back before the board next week and move, seek the board's approval on moving forward in one direction or other. But I do think the campaign has expressed interest in working with us to submit to an investigation to identify the scope of violations, and I think this is a good way to move forward.
okay, and also some possibility you can maybe come up with a stipulated resolution to the whole thing.
That is a possibility. I think like my concern at this point, Chair Marks and members of the board, is really what is the scope of violations at issue here? Because I think
Okay.
Yeah.
Okay, so, members, if we're here on August 20th, we're not here, we could do Zoom, I think, for that. What are people's availability for the 20th? What?
I'm available.
Yeah.
Okay. 1 PM,
Sure.
1 PM, okay?
Oh, so should I'll make a formal motion to table the city clerk's request for an investigation into the campaign of Daniel Leiva and to return in 1 week to hear the results of their negotiations.
Well, second.
Okay, all in favor? Aye.
Okay.
Opposed? And just FYI, motions to table are not debatable.
Oh.
That's why we went right to the vote. Okay, with that, anything further you want to apprise us of?
I just want to clarify that, our office is not large, and so we really are hoping that the Office of the Inspector General would be willing to, if the parties can come to an agreement about the scope of investigation, that the Office of the Inspector General is able to do an investigation or an audit or an investigation of the campaign. And I just wanted to confirm with Mr. Pacheco that is something that they are available to do.
Otherwise, in like the timeline I gave you was 4 weeks, or.
Well, I suppose I think, I think I'm merely at this point seeking like.
You can join them for their meetings, correct, Mr. Pacheco?
It depends on the days, sir.
Okay, we can work.
Okay.
I can join and.
All right, with that, okay. With that, is there, I don't think there's any further business we can do, so is there a motion to adjourn? Ms. Caffrey?
I'll move to adjourn.
Second.
Second, by Mr. Kennedy. All in favor? Aye.
Aye.
Opposed, same sign. None opposed, we're adjourned.